Today we start a new topic in chapter number 3 or module number 3, tendering. Topic name is a performance guarantee. So a performance guarantee is a contractor promise to complete the project undertaken. To further elaborate, a performance guarantee is a document that legally confirms that the contractor will complete the contract you have undertaken. So a performance guarantee is issued by the insurance company or a bank and to an employer on behalf of the contractor to guarantee the full and due performance of the work by the contractor as set out in a contract data. Performance guarantee give the contract employer confidence that they will meet their project deadline and have their contract completed. And in other words, should the contractor fail to construct a building according to the specification laid out by the contract, the client is guaranteed compensation for any monetary losses up to the amount of performance bond. Next is a summary of performance guarantee. So the project the employer or a principal against the risk of a contractor failing to comply with condition of contract set up between the employer and the contractor. And next topic is a benefit performance guarantee. So give the employer confidence that the contractor will complete the work and therefore makes them more applying in a tendering process. Next topic is a liquidated damages. The time is essence in a certain contracts, hence the time to complete the work is give more weight in such a contract. So in case the contractor failed to finish the work in a time limit mentioned in a contract, the owner is put in a difficulties and has to undergo damage or losses. So the legal difference between the terms damage and damages should be noted, and the term damage is used to mention including the loss of money, comfort, health or the like, and the term damages is used to mean money compensation claim by the injured party for a injury done. So it is very difficult to find out the exact amount of such a damages or losses, and has it consumption contract, it is usually practiced to provide in a contract a definite amount or a day of a delay in a form of the liquidated damages. So here how to fix the liquidated damages. So see here some of the point is given. So first is a liquidated damages refer to honest and genuine amount of the actual loss suffered and cannot be treated as a penalty because it is very difficult to enforce a penalty by law. Second is the amount of liquidated damages can be determined by agreement or by court of law, and in any case it is duty of a injured party to justify his claim of a liquidated damages, and if he failed to do so, so the court may alter or even dissolve the such amount even though it may be agreed in a writing. Fourth point is that the unliquidated damages are ordinary damages having a fixed relationship with the actual damage that has taken place, and it will increase with actual damage or vice versa. So the term penalty is used to indicate a sort of a fine which will be extra and exorbitant as compared to the damage done. And consideration should also be give a factor which beyond the control of a contractor, such as a strike, heavy floods, extreme bad weather, etc., while fixing the number of day or delay of the work. So the variation in a plan and execution of an extra item may also be treated as a sufficient gain by the contractor for extension in a time limit. Now next topic is the owner may lose his right to the liquidated damages in some of the circumstances, like here circumstances is given, four circumstances is there. First is the act of the owner. So if the owner is or his engineer not covered up by the terms of a contract was such a, it was impossible by the contractor to complete the work in a time, so the contractor is free from the payment of liquidated damages. Second circumstances is a certificate of engineer. So if the engineer or architect of the owner give the certificate for a satisfactory completion of the work and mention the amount due to contractor, so such a certificate like to be held as a conclusive proof of a completion of the work in a time. Third circumstances is that clauses of extension of time. So if a provision is made in a condition of contract for extension of a time and contractor is not given benefit of these clauses, the court may dissolve the right of the owner to collect the liquidated damages from the contractor. And fourth clauses or circumstances is that, so original contractor, so the contractor for a liquidated damages is applicable to the original contractor during the extension of the contract, and if the original contractor is removed, the clauses also automatically comes to an end, and original contractor cannot be held responsible for any liability. Now the Indian Contract Act as a deal with the vital issue of time of performance in its section 55. So the fundamental principle of a performance is that both the parties to the contract and must be cooperate and do work in a such a way that work for which the contract is signed and can be successfully completed. And Indian Contract Act as a success specifically defined as the excuse for a non-performance in his section like 41, 51, 53, 54, 62 and 63. Now there are decisions of a various court for the interpretation of a above section of the act, and they should be referred to when an excuse of a non-performance of the contract is to be deemed. Now next point is defects in a liability. So the defect in liability period is a form of a warranty that guarantee either by the relation of the contractor's performance, security and corresponding bank guarantee at the end of the period of the performance of the contract. So the defects liability period can also be covered by the retention made from the payment to the contractor over the life of the contract. So these relations are usually no more than 10% of the contract value. The defects liability securities kept cover the repairs or defects found in a infrastructure built by the contractor. If the defects in the infrastructure is detected during the defect liability period, so the contractor is notified and give the opportunity to repair the defects. And if the contractor is unable or unwillingly to repair the defects, the purchaser has to right to use the fund retained for a such purpose from the contractor. Once the defects liability period passes, if no defects were discovered or those discovered were satisfactorily repaired by the contractor, the retention money is returned to the contractor or the defects liability guarantee release as stipulated in the contract. Now last point of the chapter is a contract agreement. So the contract agreement is a legal document which bind the contract and the client to follow the rules and regulation given in the document until the work entrusted the contract is completed or signed by the both the parties. And the contract agreement normally contains the title page with the name of the work, contract agreement number. Second is a index page prelink the contract of the agreement with page reference. Third one is a tender notice with a description of the work, location, time, period of completion, etc. Fourth one is a bill of quantity and total cost of the work duly calculated. And fifth one is a schedule of issue of material and rate. And sixth one is a general specification given the clauses and types of the work. And seventh is a detailed specification for each item of the work and material. Eight is a lead particular for a brick, sand, jelly, etc. And ninth is a complete drawing with a plan, elevation, section, side plan and other relevant drawings. 10th is a condition of contract giving rate of labor, material, tools and plant, progress rate, etc. And 11th is a special condition regarding the nature of the work, royalties, labor amenities, etc. So here we complete our lecture, and here also chapter is finished. Thank you.